Hello, can you all hear me?
Oh, really?
Good evening, can you all hear me? Please, if you have your mic, yeah, if you have your all right, thank you. Good evening, everyone. Good evening, everyone. I trust we're all doing great.
Good evening, sir.
Yes, yes, welcome to class. My name is Dennis Williams, and I'll be helping moderate this particular session. Welcome to week 1 of the JIIPCC Mentorship and Internship program for the ADR mentorship course. All right. This course is brought to you in partnership or in collaboration with the Settlement House ADR Training Institute. All right. They are partnering with us to bring this course exclusively to you. You would have the opportunity to be able to participate in their to become a certified ADR practitioner if you want further training as regards matters that concerns ADR. But so far, we'll be kicking off today's class with just basic introduction, firstly, of what ADR is. Our topic for today is an overview of ADR. And I would like to introduce all the mentors that will be engaging with us throughout the course of this particular program. So to kickstart it, I would first likely, because of the amount of flyers that we have, we would usually read through every mentor's flyer, but because of the sheer amount or the number of mentors that will be having run through this program with us, I will just be reading a little bit from their profile. I will not be reading everything, a little bit from their profile, just to give like a kind of introduction to them, right? So that we have an awareness of our mentors, who our mentors are going to be, and how our engagements are going to look like. I can see we already have a few of them on the call, right? We'd like to specially welcome first and foremost Mr. Nyacham Namwan. Mr. Nyacham Namwan is the Executive Director of Settlement House ADR Training Institute. Nyacham Nawan is a lawyer and the principal partner of the law firm Nyacham & Co., a law firm based in Kaduna, Nigeria. He's a certified teacher, trainer, and facilitator. He is a faculty member and the executive director of the Settlement House ADR Training Institute, an institution for training, certification, and practice of alternative dispute resolution. He is also a member as well as faculty member of the Nigerian Institute of Chartered Arbitrators, a model arbitration certificate institution in Nigeria. He is a certified dispute resolution specialist, an international mediation campus trained mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. All right, he's a certified conflict manager, a certified ADR registrar, / secretary, a holder of Mediator Academy, United Kingdom certificate in commercial mediation and mediation accredited by the Institute of Chartered Arbitrators, UK, a medical law enthusiast and employment and labor law expert. There's still so much more on his profile. We'll be sending out the list of the mentors profile to you after the class so that you can get to familiarize yourself with the mentors we'll be having over the course of the program. Our second mentor that will be helping us break down ADR as a course is also going to be Ms. Baratu Dangana. Ms. Baratu Dangana is a seasoned legal practitioner with a strong passion for alternative dispute resolution. She is a trained mediator and arbitrator committed to fostering amicable, efficient, and sustainable dispute resolution mechanisms, a member of the Nigerian Institute of Chartered Arbitrators, the Settlement House ADR Training Institute, and a recognized neutral with the Nigerian Chamber of Commerce, Abuja. She brings a wealth of experience and professionalism to every matter she handles. She was called to the Nigerian bar in 2007. Baratu holds an LLM from the University of Jos and is currently a partner at JB Dauda and Co., a firm with a distinguished reputation in legal practice and ADR advocacy. Her legal career is marked by consistent dedication to dispute resolution outside traditional courtroom litigation. All right. You can read more of our profile. Like I said, we'll be sending it out to you subsequently after the class. Thirdly, we have Sewe Ese Yaji Ando. Sorry if I did not pronounce the name very well. I'm sorry about that. Mrs. Ando is a versatile and results-driven corporate attorney with a vast professional experience in legal and regulatory compliance, company secretarial alternative dispute resolution, administration, and legal human resource management, with a demonstrated history of working with the legal, financial, hospitality, and information technology services industry with close to a decade of experience. She has successfully resolved numerous commercial and workplace disputes, implemented streamlined administrative procedures, HR policy, and procedures, resulting in saved time, reduced costs, improved efficiency, legal compliance, and productive work environments for organizations. Like I said, their profile will be sent to you so that you can familiarize yourself with them. Our third mentor or fourth mentor, if I'm not mistaken, is Miss Amina Ezekiel. Miss Amina Ezekiel is a distinguished legal practitioner with 8 years of post-qualification experience, called to the Nigerian bar in 2017. She earned a master's degree in law from the prestigious University of Jos in 2025. Amina is passionate about mediation and teaching, serving as Assistant Secretary of the Curriculum Review and Development Committee at Settlements House Alternative Dispute Resolution Institute, where she contributes to developing comprehensive mediation training curricula for CADA membership, aligning with international best practice. Additionally, she serves as Assistant Secretary of the Nigerian Bar Association Cardinal Branch. In her free time, Anna enjoys reading and writing. We're happy to have her with us. Thank you so much, Ma. Our fifth mentor that will be expecting to help run us through ADR is Mr. Tohid Amuda. Mr. Tohid Amuda is the founder and the managing partner of Lovocates Attorney, a firm of lawyers, investment consultants, and arbitrators. He is an international commercial dispute attorney and an investment consultant. He has significant experience in commercial litigation, commercial arbitration, and investment treaty arbitration. He holds a Master's of Law degree in London, United Kingdom. He has written a significant number of articles in dispute resolution space and holds several awards. His experience is multi-jurisdictional. In his role as an investment consultant, he regularly assists businesses in raising capital for their expansion, ranging from private equity to venture capital. Next, we have Mr. Idris Mohammed. Mr. Idris Mohammed is a distinguished legal practitioner with extensive expertise in telecommunication law, ICT law, arbitration, litigation, and corporate law. He holds a fellowship from the Chartered Institute of Arbitrators. He completed his LLB, that is his bachelor's in law at Ahmadu Bello University Zaria, and subsequently obtained a postgraduate diploma in computer and communication law from the University of London. He further pursued an LLM in corporate and commercial law from the same institution. Notably, he holds a diploma in international arbitration from the Chartered Institute of Arbitrators UK. Idris is a managing partner at Firma Firm, a leading corporate commercial law firm in Kaduna, Nigeria, where he showcases his litigation proficiency in appellate courts, state and federal high courts. Mr. Idris, we are happy to also have you on board to help us journey through ADR. Next, we have Mr. Babajide Adams. Mr. Babajide is a legal practitioner called to the Nigerian bar in September 2011. However, he began his ADR training as early as 2008, where he was when he was an undergraduate at Olabisi Obanjo University, with Association of Professional Negotiation and Mediation, now Chartered Institute of Professional Negotiation and Mediation. He wrote his university project on ADR. He has also been trained by the Chartered Institute of Arbitrators. He is a member of the Business and Insolvency Practitioners Association of Nigeria. He's a member of the International Association of Prosecutors. He's also involved in the Lagos State Settlement Week as a counsel. Presently, he's the director of Resolution Neutrals International Limited, where he handles ADR sessions and training. He's currently writing his thesis on ADR in commercial disputes, emerging trends and legal implication in Nigeria as a lead city university of his LLM. Last but not least, for the mentors that we'll be having over the course of the next 7 weeks is Mr. Isaac Asare. Mr. Isaac is a highly respectable paralegal, alternative dispute resolution expert, mediator, and peace and security consultant with over a decade of experience in conflict resolution. He's the founder and president of both the African Center of Collaborative Dispute Resolution and the Association of Complete Peace and Security Experts in Africa. As a trainer, mediator, negotiator, arbitrator, and paralegal, Isaac has played a pivotal role in shaping ADR practice across Africa, training professionals, business executives, and community leaders to resolve dispute efficiently. His expertise spans family, labor, mining, commercial, and land disputes, helping individuals and institutions achieve amicable and lasting solutions. He is the author and the commercial mediation handbook, which serves as a practical guide for mediators and negotiators. His thoughts leadership has contributed to the advancing ADR framework and policies in Africa. We want to say a special welcome to all our mentors for the ADR course for the Q3/4 2025 mentorship and internship session. So not to waste any of our time anymore, we've spent quite a while reading through profiles. So we'll be handing over to Mr. Nacham to give us a brief introduction into what we'll be handling over the course of the next 7 weeks, and also especially in today's class. Mr. Nacham, if you are with us, I would like to hand over to you. You're welcome, sir.
Thank you very much, Mr. Dennis. Thank you so much for the time, your dedication to this course. Before I commence, I want to say a big congratulations in advance to all the mentees who have created time to register for this course, for this mentorship, and are willing and ready to ensure that they take part in this training. I will want to say that this is actually an opportunity for everyone, young practitioners, ADR enthusiasts who are interested in building a career for themselves in alternative dispute resolution. Now, let me start by saying that I will need all mentees to take this opportunity and privilege very seriously. As we all know, for those who are passionate about ADR, you know that ADR has become one of the most expensive training to do in Nigeria. And we have collaborated to be able to bring this to your attention. You know, in the course of this mentorship, you are going to be going through a lot of in fact, you are going to go through ADR generally, both mediation, arbitration, negotiation, among several other things. So you are going to be going through them. So please, this is not something I will want you to take lightly. Now you are going to be given assignments, you are going to be making research, you are going to be making presentations, and the mentors will be available to listen to you, to know areas where you have questions, you need clarifications, they make relevant contributions, and that is the shape and the way this mentorship is going to be. And we expect that you are going to be dedicated to the cause. I also hope and believe that unlike some uh, previous mentees who sometimes you see them, they may be available today and then the next time they are not available. I want to charge all mentees to try as much as possible to attend all the classes that are meant for them. It's a weekly meeting every Wednesday. I will charge you to ensure that you create time to take part in this mentorship from the beginning to the end. Ask relevant questions, go and make research, come seek clarification, take advantage of the mentorship. For those who do not know, maybe you can check up Settlement House ADR Training Institute, maybe online or anywhere you want to check, on social media. It is one of the institutes that trains and certify ADR practitioners in mediation, negotiation, arbitration, among several other ADR mechanisms. So those of you who are very serious, who are serious with this particular course, this may just be an opportunity for you to switch over from your mentorship to a certification training that Settlement House usually undergoes or takes or runs. So I am expecting that you will be dedicated, you will be committed in the course of this. Now, in the course of this training mentorship, we are going to be having we are going to be taking we are going to be looking at some relevant aspects of ADR. And I expect that you are going to be writing down questions, as others are making presentation. I expect that you are going to be writing down relevant questions that you need to ask clarification, because when you miss the opportunity, before you can get the opportunity again, it could be paid, maybe paid consultation, or a training that you have to pay for, among others. For the fact that this training is presented to you free does not mean that you should take it for granted. Now, these mentors are actually very, very serious-minded people uh, who are very busy in their sphere of life, in the area of their practice, and they have created time out of their busy schedules to be with you in the course of this mentorship. It is just a way of giving back to the society, giving back to young practitioners and providing them an opportunity for them to be mentored, to be guided into different areas and aspects that they may be interested in. So as the mentors create time and avail themselves for mentorship to attend to you, please, I will beg you to ensure that you create time to be to create time to attend. Now we are going to be having about 6 or topics. We're going to be a 6 weeks training, and you are going to have the opportunity of getting to know about an overview of ADR, general overview. Generally, you're going to get to know about that. And then secondly, the next week, we are going to be talking about mediation and career opportunities in mediation. And then the third week, we are going to be looking at arbitration and career opportunities in arbitration. And then in week 4, we are going to be looking at practicals, mediation practicals, simulations, among others, so that you'll be able to practicalize what you have learned. Then the 5th is going to be a practical arbitration session. You're going to have a practical in arbitration. So please, as you are listening, ask relevant questions that will help you build up your career and enable you to be able to function properly in your practicals, both in mediation and arbitration. And then week 6 is going to be, depending on the aspect you choose for yourself, you're going to be human rights or business, or is going to be the AFCFTA, that's the African Continental Free Trade. Maybe that may be, and then you have the fundraising, and then the HI clinic for CV writing, and getting the best jobs. These are all customized because it's a mentorship. They are all packaged together to ensure that you have everything that you need as a young practitioner, as a young professional, so that you will not be stranded, or you will be properly guided as you make informed decisions. These are the things we're going to be covering in the course of this mentorship, and we trust that is going to impact both us and you. As mentors, also, we are learning from some of the presentations that you'll be making. So please ensure that you make research, make presentation, knowing that we are also looking forward to learning from you. Having said so, I want to thank all the mentors who have availed themselves today for this mentorship. And as I hand over to Dennis, so that we'll go straight to the presentation for today. The group that is ready and available should proceed with the training, with the presentation for today. Thank you very much, Dennis.
All right, thank you very much, sir. Okay, just a minute.
So, before he comes up, do we have anyone who has any question before we commence? Do we have any question? Anyone? Okay, Mr. Dennis, I think this will be the right time to put on our camera so that we can have the general snapshot, right, before it gets late and dark.
Yes, sir. We'll be doing that right now. Sorry, my own background is a bit dark already. It's dark over here where I am. So please, if you're in a place where that is a bit lighted, please turn on your video so that we can take a quick picture.
Everyone, please put on the camera so that we can have a snapshot.
Yeah,
Everyone,
so please, we'll like for all the mentees to turn on their videos so that we can take a quick screenshot of, to more of give account to the fact that, you know, this class is happening. So please, if you can turn on your videos so that we can all see you. All right, we'll take the screenshots quickly and then we'll quickly go to presentations. We'll take presentations and then the mentors will come and give us their discourse for today. All right, so please turn on your video cameras. Thank you.
Mr. Isaac, thank you for joining us. I can see Baratu, thank you for joining us. Thank you. I can see all of you. Please ensure that you have a very wonderful snapshot for us. Please put on your camera.
We are almost done.
Oh, Mr. Idris, thank you so much for joining us. I can see you. We appreciate you. Thank you so much. I can see a lot of persons, they've not put on their cameras. Please, we want to see your faces. It will be great and good to see your face.
Recording in progress.
All right, we are done. We are done with that. Thank you very much, to everyone who cooperated. So not to waste any further time, we'll be going straight into presentations. So we expect to have 2 presentations in class today. Please, if you have your mic unmuted, please try and mute it so that we don't get to hear the noise in your background. Thank you. All right, so we'll be going straight to Mentee's presentation. We have 2 groups who will be presenting in class today, Group 1 and Group 2. And I believe both presenters are ready for their presentation. So I'll be handing over to Group 1. Your presentation time is 10 minutes. All right, it's 10 minutes. So please, let's try as much as possible to stick to time. All right, so Group 1, if you're ready, the floor is yours. Kindly share your screen with us so that we can see your presentation while you make it. Group 1 presenter, the stage is yours. Do we have the presenter for Group 1 in class?
If you are making presentations, ensure that your camera is on so that we can see your face and relate with. Thank you, Omotayo. I can see you here. Thank you so much for joining. Yes, Group 1.
Group 1, are you guys here with us? Are you ready for your presentation? Okay, not to waste any time. If Group 1 is not yet ready, we don't want to waste any time calling. So Group 2 would start with you. If you are ready, please kindly turn on your video, share your slides so that we can start your presentation. Please, presentation is 10 minutes.
Okay, sir, noted. Let me do that right away.
All right, thank you, Mariam.
I can see Babajide Adams. Thank you so much for joining us. Are you having difficulty sharing your screen?
No, sir. No, sir. I'm just turning on my video. I'm about to share my screen now.
Okay, go ahead and share the screen now while searching your video. Okay, Mariam, having any difficulty?
I'm about to start now. I was having issues with my audio.
Okay, your audio is good.
Okay, yes, I've started. Okay, I think you should come up now. Okay. Let me open the PowerPoint. Okay. Can anyone see my screen?
Yes, we can see your
Yeah.
screen.
Yes, we can see.
Okay. Okay.
Okay, so can you go and
Okay.
click
Thank you.
on
Good evening, everyone. My name is.
good. Go ahead.
Sorry.
Go ahead.
Okay. Thank you. Good evening, everyone. Okay, thank you. Good evening, everyone. My name is Mariam Abubakar Donguza, the presenter for Group 2, and today I'll be presenting on the topic Understanding Alternative Dispute Resolution Mechanisms, Arbitration, and Conciliation. So, before I begin, I would like us to know what exactly ADR is. So, ADR stands for Alternative Dispute Resolution, and it's basically a way of resolving disputes without litigation. So this essentially, involves a way or a method of resolving disputes between parties without necessarily going to court. So it's basically an out of court settlement. So the purpose of ADR is to resolve disputes efficiently, to promote communication and understanding between parties, to provide flexible solutions to any problems or issues that the parties may be facing, to reduce cost backlog and congestion, and to as well preserve relationships. So some common forms of ADR include arbitration, conciliation, mediation, negotiation, and a multi-door courthouse. But for today, I would be treating the first two, which is arbitration and conciliation. So what is arbitration? The World International Property Organization defines arbitration as a procedure in which a dispute is submitted by agreement by the parties to one or more arbitrators who make a binding decision on the parties. So this basically involves when two or more parties who are in dispute or who have like a conflict will submit an agreement to one or more arbitrators to make a binding decision on their matter, and this is called an award. So the arbitrators would issue out an award which is expected to be followed by the parties. So it's a binding decision that the parties are expected to follow. And arbitration in Nigeria is governed by the Arbitration and Mediation Act, Act 2023. So steps in arbitration. So these are basically the steps that
Okay,
arbitrators follow.
Mary, I'm sorry. Please, to all mentors in the house, we are expected to take note of certain things in the course of presentation that we may want to make comments on. Thank you very much.
Okay, sir. Thank you. Okay, some steps that are taken in arbitration include the agreements to arbitrate or initiation, then the selection of arbitrators, submission of statements or evidence, hearings and deliberation, issuance of arbitral award, and enforcement in court if necessary. So the agreement to arbitrate is basically when the parties would submit to an arbitrator or an arbitration house um what they want the arbitrators to look at and give an award over. Then the selection of arbitrators. So after that, it's the parties can now decide who they want to act or serve as their arbitrators. Then parties will submit their statements or evidence. Then there's going to be a hearing. So, and this is usually done in private. Then the issuance of arbitral award by the arbitrators, then an enforcement in court if it is necessary. So here are some advantages of arbitration. So faster resolution. Arbitration is essentially faster than the litigation, which is the normal going to court process. Arbitration can be concluded within months, but going to court can take years before a matter is decided upon. Cost effective. Arbitration it can be less expensive than litigation. However, in some situations, arbitration can also be expensive. Then confidentiality. As I mentioned earlier, the proceedings are usually done in private, not in public. So the parties, sensitive information or personal information is properly safeguarded. Arbitration is also flexible. It provides flexibility. Um, Arbitration also preserves relationships, and parties are given the choice to select their arbitrator. So they are are given that opportunity, that room to select who they want as their arbitration, and it can come from relevant fields. Then arbitration also has some disadvantages, which include fairness concerns. So mandatory arbitration clauses may disadvantage weaker parties. Then we have arbitrator bias. When choosing the arbitrators, there may be some form of subjective or favor towards or favor in respect of powerful parties. They can maybe employ maybe arbitrators that would may disadvantage weaker parties. Then unbalanced power. So employers or large corporations often have the upper hand. Unpredictable outcomes, no jury, lack of transparency, and many more. So the next form of ADR that I would be looking at is conciliation. So conciliation is a form of ADR where a neutral third party receives submissions from disputing parties, provides a non-binding evaluation of their rights and obligations, and proposes recommendations for settlement. So conciliation is like the opposite of arbitration. In arbitration, you have one or more, arbitrators giving out a decision that is to be enforced, which is the award. But in conciliation, that does not exist. The neutral third party does not give out any decision or any award that the parties have to implement. So some characteristics of conciliation include it is voluntary and controlled by the parties, with the conciliator facilitating communication and suggesting fair outcomes based on both legal positions and wider interests. So the conciliator's job is basically just to provide, guidance to the parties and assist them in, coming together and deciding, what is best for them and how best to solve their issues. Then these are some steps in conciliation. So just like in arbitration, we have the commencement or initiation. So conciliation essentially starts when parties voluntarily agree to use it. So Section 38, Sub 1 of the Arbitration and Conciliation Act 2004 provides that a person who wishes to initiate conciliation shall send the other party a written request to conciliate. The next is the selection of the conciliator, as in arbitration, where there's also a step there that talks about the selection of an arbitrator. Then the next we have introduction and opening statements, exploration and negotiation, then resolution and agreements. Like I mentioned earlier, the job of the conciliator is to guide the parties. So here, parties are guided by the conciliator in order to work towards a mutually acceptable settlement. And once agreed, the terms are documented and signed, making it binding. So these are some advantages of conciliation. It is cost effective, it's flexible, it preserves relationships, it is confidential. So part sessions again are in private, just like in arbitration, unlike in court where the proceedings tend to be in public. Then conciliation too is also fast as well. It's a faster way of resolving disputes. Then we have a less corruption risk because the conciliator in question is usually someone who is neutral. So you don't bring a conciliator that maybe has a conflict of interest or interest with one of the parties, which can affect the outcome. Some disadvantages of conciliation include it's not binding. So in arbitration, the arbitrators will make a binding decision, a binding outcome, essentially, where the parties have to follow that decision. But in conciliation, the conciliator or conciliators just guide the parties into making a mutually acceptable agreement. Then weak enforcement, and there's also limited scope. So there are some key differences between arbitration and conciliation, and they include the nature of the process. So as I mentioned earlier, in arbitration, the neutral arbitrator gives a binding decision, but in conciliation, the neutral conciliator helps parties reach settlements. No decision is given, that is, no award is given or passed on. Then the role of a neutral third party. So the arbitrator acts like a judge, acts like a private judge. The conciliator, on the other hand, just guides the discussion and suggests options. Then the binding nature, arbitration is binding and enforceable. Then conciliation outcome is not binding unless the parties agree to it. So arbitration is formal in nature, while conciliation is more informal in nature. And in the arbitration, the arbitrator has the decision making power. So the arbitrator has the power to make an award, give a decision. But in conciliation, it's different, where the parties have the liberty to decide and make mutually acceptable outcomes for both of them. Then effects on relationships. Arbitration, if one wins or one loses, it may stray relations. Conciliation, on the other hand, seeks to promote cooperation and preserves relationships. Confidentiality. So essentially, both forms of ADR are confidential in nature and are usually held in private and not in public, like in court. Then these are some real life examples or cases, and the first we'll have is for arbitration. So, in the case of international arbitration and conciliation, Yukos Capital SAL versus Russian Federation, Yukos Capital won an arbitration award against Russia for unpaid loans. The award was upheld in multiple courts despite Russia's claim of fraud and interference. The next case is Mekunweye versus Imukwede. So, in this case, the Supreme Court upheld an arbitral award in favor of the landlord. Then another case as well, or case study, is China Aviation Tech Arbitration, Shanghai 2008-2021. So in this case study, a Chinese aviation company and a foreign contractor disagreed over delayed R&D services under a tech contract. They went to arbitration at the Shanghai International Arbitration Center. So in arbitration, sometimes the parties in question can go to arbitration institutions or centers like this one here, the Shanghai International Arbitration Center, to resolve their disputes. These are some cases for conciliation. The first here we have is the Timor-Leste versus Australia Timor Sea conciliation. And this was the first compulsory conciliation under the UN Convention on the Law of the Sea to resolve boundary and resource governance issues in the Timor Sea, resulting in a groundbreaking treaty signed on March 6, 2018 that established permanent maritime boundaries and a framework for resource sharing. Another case is Hogard and Schultz versus Lithuania. So in this case, a Danish company suffered losses after Lithuania paid in depreciated US dollars following the 1993 evaluation. This dispute was referred to the Danish Lithuanian Conciliation Commission under the 1923 treaty. The commission proposed that the Danish claim be reduced by half with the balance paid in litres, but Lithuania rejected the proposal. This illustrates that conciliation produces non-binding recommendations and relies on the parties' consent. So basically, in conclusion, ADR is a way of resolving disputes or conflicts between parties outside of courts. So it is the opposite of litigation, and some forms of ADR are arbitration, conciliation, mediation, negotiation, and a multi-door courthouse. That brings me to the end of my presentation. Thank you guys for listening. Thank you so much, everyone, for listening. Does anyone have any question?
Yes, hello.
Yes, I can hear you.
Good evening, everyone.
Good evening.
I don't know if this is the time for mentors' comments or that's later. I can be guided, please.
Oh, all right, sir. So the comment would
So we are going to discuss group 2 first, group 1, then after that the mentors comments.
Okay, that's noted. That's noted. Thank you very much. I hope I don't forget. I'll note it somewhere. Thank you. Thank you very much.
All right. All right. Thank you so much, Miriam, for that wonderful presentation from you. Well done to you and to your group members for putting together the presentation. It was delivered very well. So we'll be calling on group 1 to make their presentation. The group one presenter, if you're ready, I'll be helping with the sharing of the slides. So you can go ahead and come up and introduce yourself while I share your slides.
Good evening, everyone. My name is Adebayo Victoria, and I'll be presenting for Group 1. So our topic for today is, please, can anyone hear me?
Yes, we can hear you, Victoria.
All
We
right,
can
sir.
hear you.
Okay. Our topic for today is an overview of alternative dispute resolution. I'll be talking on negotiation and mediation. So before I start, what is alternative dispute resolution? Alternative dispute resolution is a medium by which disputes are resolved outside of the courts. That is, parties in conflict can resolve their disputes, their differences without going to the courtroom or going through the processes of litigation. And ADR is governed by the Arbitration and Mediation Act of 2023. It is a so we have different kinds of alternative dispute resolution. We have the negotiation, we have mediation, arbitration, conciliation, neutral evaluation, and so on. I would like to proceed to negotiation. So what is negotiation? Negotiation is a dispute resolution process whereby two or more people, they resolve their disputes outside of the court. That is, they reach a joint agreement or a decision without going to the court. And negotiation mostly happens between buyers, sellers, employer and the potential employees, and so on. And one thing about negotiation is that it is usually voluntary. One key characteristic is that it is voluntary. That is, the parties choose to negotiate on their own without going to the court, without involving the courts. And also bilateral and multilateral. That is, if it is bilateral, then it is between two parties. But if it is multilateral, then it involves more than two parties. That is, it involves a group of people. Also, negotiation is non-adjudicative. That is, it involves just the parties. There is no court ruling. There is no need for a third party in negotiation. Also, negotiation is confidential. That is, it is private. It is not done in a public space. It is between the parties involved alone. Also, negotiation is informal. That is, there are no rules in negotiation. The parties involved are free to adopt any rule in which they feel like it will be convenient for them. So I would move to the steps in negotiation. The first step is the planning and the facts. Okay, I'm sorry. I'll move to the steps in negotiation, the planning and fact finding. The first step in negotiation is for the parties involved to plan. They will strategize that, okay, this is what we want to talk about. These are the issues. This is what is involved in this case. And then they will make research about the facts. They will discuss about the possible outcome of their discussion. So I'll move to the second one, which is the opening phase. In this opening phase, the parties, they talked about, they set the tone and make sure they are polite in their tone and make sure not to say things that will embarrass the other parties. Then the discussion phase. This is where they present their cases. There is need for active listening at this stage, so they will be able to get their facts right and know if they are convenient with the terms of the case. Then we have the bargaining phase. We have the proposal phase before the bargaining phase, and in this proposal phase is where they make offers that, okay, this is what I have to offer, this is my own terms. Then the other party can be like, let's bring it down a little, it is too high for me, or it is not convenient for me. They'll make offers and counter offers. Then we have the bargaining phase. Also, after in the bargaining phase, they make proposals, they evaluate their proposals. Then after the bargaining phase, we have the closing phase. That is where the decision is made. Then when they come to a conclusion, they will have the post decision phase. Now, what are the importance and limitations of negotiation, one of the importance of negotiation is that it is cost effective. That is, it is cheaper when compared to litigation. It is confidential. There is no public involved. It is just the two parties that are involved, and it also preserves relationship. Unlike litigation, where tensions are rising, and parties are under the pressure of I have to win, I must win against the other party. In negotiation, there is nothing like, there is no pressure and there is no tension. And also, what are the disadvantage? Power imbalance. In a case where a person has upper hand than the other person, then the one who has a upper hand has a tendency of winning against the other party, or has a tendency, or the one who has a lower hand has a tendency of bending to the rule of the one who has a upper hand. And then in negotiation is not suitable for all kind of disputes, and also there is no legal enforcement since there is no involvement of the court in negotiation. Now we move to mediation. What is mediation? Mediation is a process whereby, is a mechanism whereby disputes are resolved outside of the courtroom by a neutral third party called the mediator. When in a case where there is a dispute, the mediator will come in. He is neutral. He or she will be a neutral person. He is not involved with either of the parties. Then he will come in and step in to resolve their disputes. Now, in mediation also, just like negotiation, it is voluntary. The parties choose to hire a mediator to help them settle their disputes, and there is neutrality. The mediator has to be neutral in the case. There is also confidentiality, that is, it is not public, and mediation is also flexible. The mediation process is flexible, unlike the court process where you have to go through a rigorous process and all of that. Now, the advantages of mediation: we have cost effective, it is cheaper, it is time efficient, it preserves relationship just like negotiation, and it is also confidential. Now we move to the disadvantages of mediation. There is no guarantee of agreement, as the parties, they can choose to, if they are not convenient with the decision of the mediator, they can choose to go not to follow the process. Also, there is no legal precedence. There is no precedent that, okay, this was what happened in the case of this person, so let's follow this rule. They do what works for them. And also, the decision is dependent on the mediator. It is the conclusion the mediator comes to, that will work for them. And it may not be suitable for all kind of cases as well, just like negotiation. Now, for a mediator, we have some standards, some ethical standards that is required of a mediator. One is diligence. A mediator has to be diligent and has to be competent in carrying out his or her duty. A mediator has to be impartial. That is, he doesn't have to side with one party against the other party. A mediator should avoid conflict of interest. The mediator should not have a conflicting interest with the parties he is to mediate for. A mediator has to be confident, has to be competent. Also, a mediator must know how to keep things confidential and not breach their agreements. And a mediator also has to conduct the processes according to the standards, and not he has to be go according to the standards set in mediation. In conclusion, alternative dispute resolution, it offers effective ways in which disputes can be resolved outside of the court. So it is flexible, it is cost money, and it also saves time. Thank you.
All right, thank you very much, Victoria, for that wonderful presentation. Thank you also to Mariam for our presentation. Now, time for the mentors. I think, is it Mr. Idris that wanted to make comment?
No,
We
it's
can
Mr.
see,
Toib. Hello? Hello?
Hello,
Yes.
it's Tohib. Tohib.
Okay, Tohib. Okay. Okay, so it is time for the mentor. So Tohib, you can go. Mr. Idris, let's take 5 minutes or thereabout and make our contributions. And then if there are questions, we'll attend to them.
Yes, thank you very much. Just very briefly, well done to the presenters. Just want to quickly make a quick comment on Miriam's presentation. I don't know if it affects the second presenter as well. I think Victoria, right? So I don't. Can you confirm if you can hear me, please?
We can hear you, sir.
I hope
Okay.
I hope the mentees are taking notes.
Yes. So good evening again. Good evening again, everyone. This is Tohib Amuda. So just a quick comment, right? When Miriam was making a presentation regarding conciliation, right? And well done. You referred to the ACA, although at the beginning when you were talking about arbitration, you cited the AMA, the Arbitration and Mediation Act 2023. But when you were addressing the mediation, the conciliation points, you referred to your reference was to the ACA, that's the Arbitration and Conciliation Act. Of course, you will know that the ACA has been repealed, right? So, I mean, that's a given. It has been repealed and, of course, replaced by the Arbitration and Mediation Act. Now, your reference to conciliation should be under the AMA. For it not to be confusing, the AMA has specifically provided, it provides for mediation. Now, we might be wondering, so what happens to conciliation under the old law? Right? The definition provision under the AMA now says that when there is any reference to mediation, that definition will also attach to conciliation. So the provision of the AMA now, as long as it covers mediation, that also extends to conciliation. And the principles and procedures shall apply accordingly. So that's governing law now, the extant law in Nigeria. You understand? Just so you can take note of that. Secondly, and I think this applies to everyone, when we talk about arbitration, and of course, I know that we all talk about the cost-effective nature of arbitration as an advantage. Indeed, we can say it's cost-effective, but I won't say now that being a practical session, just so you know, being baby budding lawyers, arbitration enthusiasts, businessmen on the call, you have to bear in mind that indeed arbitration can be very, cost demanding, right? If I'll put it that way, because sometimes payments run into millions of dollars, sometimes it's millions of naira, right? So a typical claim, an arbitrator can charge you 30 million, 20 million or so. So, this is what you are paying for services of the arbitrator. Right. So you want to look at it. Indeed, the benefit that I would say is the time that you save. And maybe we say it's time effective or so that, we put it that way. Right. The time that you save, you're able to get your results. I don't want to go into the long process of enforcement again, which now takes you back to court. Right. So let's just keep it about you getting your award, because again, the enforcement and recognition of the award is another process entirely. In the Nigerian system. So let me just leave my comments there. Thank you.
All right, Mr. Idris, are you with us?
Yeah, I'm with you. Thank you so much for having me. I must commend the presenters. Excellent presentations. You guys were on top of your game. It was obvious that you had prepared these papers by yourself and you knew to a larger extent what you were talking about. My intervention will be very short and it will go straight to the point. And I'll raise and discuss on two basic issues. First, definitions. when we're talking about alternative dispute resolution, it's all encompassing. It's not just related to resolving disputes without litigation. The definition, a comprehensive definition of alternate dispute resolution is finding solutions to your problems, to any dispute that you may have. It's not necessary that we should always have a comparison on it to litigation. I'm sorry I didn't introduce myself. My name is Idris Adini Mohammed. I am a fellow of the Chartered Institute of Arbitrators, United Kingdom, and I'm glad to be here with you to act as your mentor. I've had about 15 years or more experience in ADR. I'm also the founder of Pharma ADR, which is a commercial center, an ADR center and training institution in Kaduna. So back to the issues. So I've given my the talk on the definitions. The last speaker, Tohib, actually mentioned the issue of enforcement. Yes, but I'll be looking at it from another angle. Now it depends on. I heard it repeatedly with most of the both speakers that enforcement is easy in some places, enforcement is easy in some other places. Yes, it's true. Yes, you might have to look at the issue of enforcement has been easier across board. But one of the greatest attributes of alternate dispute resolution is that it is party driven. So if parties, whether it's negotiation, conciliation, arbitration, or mediation, is what parties agree that we go. Of all of these, yes, the only one that makes an express provision for arbitration and to a larger extent is mediation too, where you have a settlement agreement that is adopted in court as a consent judgment. But in all the others too, you can also enforce if parties agree. So enforcement is also party driven and it can happen across board. My last intervention has to do with conciliation. While the last speaker had tried to, the last mentor in his intervention had tried to or had stated the position of the law where they said the same provisions as relates to mediation now applies to conciliation. I noticed from the last group speaker, I think that's the group 2 presentation, that you cannot find any Nigerian example of conciliation. Correct me if I'm wrong with the older mentors. I have had in more than 15 years ever seen any process that started as a conciliation. What normally happens is people go into mediation, and by the time they start looking at it, okay, can you become like our conciliator, so that we can now move into a conciliation session. Point I'm making is conciliation is not that prevalent or knowledgeable or used in our jurisdiction. Please correct me if I'm wrong. But in my own experience, I've hardly ever seen a process that commenced as a conciliation process. This is just to make it practical and drive it home for you. There are a lot of discussions as to the advantages of ADR, and the last mentor also mentioned this point. That is the fact that how cost effective is it? Yes, and then actually how timeous can it be? And that is why I must commend the efforts of Shati and Nanchang for always trying to mentor people right from this beginning, because we are already shaping their thought processes as they come out, and maybe we can start that change that we need to have in all of these things. Number one, I agree on textbook and on paper. ADR methods are supposed to be cost effective and are also supposed to be timeous. But in practice, and what you actually see happening in our everyday practice is that there can be some form of huge cost involved with arbitration, and also there can be some of time wasting methodology that may be used by both parties. But I do not want to belabor you. But I think there's still a lot of work to be done in getting and in resolving this. AMA has tried to change some of these things, but it is still, I still think there's still a lot of work to be done. We can share our ideas on this in subsequent programs. But in a nutshell, I think you've done a fantastic job. You've done very well. You've taken your time. The two had, even at the end of their presentation, a whole list of their references, which is something I would encourage you to do. In most works nowadays, it is better you state where you're getting your information from, and it gives it credibility, and it also shows that you have done your research. So in a nutshell, I'd like to say kudos to all of you, and well done. Excellent presentation. Thank you.
All right, thank you very much, Mr. Idris, for your intervention. Which other mentor in the house who want to say something, please?
Okay, I'm here. Okay. Good evening, everyone.
Right.
Okay. Thank you, Nanchan, for the invitation. And let me comment on the... Can you hear me? Nanchan, you were trying to say something. Am I audible? Please, can you confirm if I'm audible?
Can hear you.
Thank you.
We hear you.
Okay, great. Let me welcome you to Ghana. I'm speaking from Ghana. My name is Isaac Asari. I'm the founder and president of the African Center for Collaborative Dispute Resolution, and I'm happy to join you this evening. Let me commend all the presenters and the groups for their wonderful presentation. A few key points that I noted down that I want to share with you. The first presenter, which is group 2, when she was presenting, let me also comment that I've seen the presenters are women who are taking up the bold step to lead and also to present, so which is a good thing. We need more women in ADR because the women are one of the best mediators that you can find, and we hope more women will join like that.
Sir Isaac.
Yes.
What mediators? Don't.
Why do you want to put sand in my soup?
Oh, yeah. Be
Allow women to chop fast. Allow women to chop fast. Okay, Danchan, let me continue. So during you said more common forms, and you mentioned multi-door court. The multi-door court is not a form. It can be maybe a form of ADR, but when we are talking about maybe a form or types of ADR, the multi-core is just and something that the judiciary of the Nigeria have used to complement the services that they do at the judiciary. For instance, if you come to Ghana, we have the court annexed mediation or court connected ADR at the courts. But that does not mean that is a form of ADR. That is a way that they have adopted to practices. But so when you go, the mediation and the arbitration that you mentioned, you find those forms of ADR being practiced at that level. So it means that the court is using it to augment their services. So kindly take note of that portion and look at it again so that you won't say that multi-door court is one of the types of the ADR that you know, but it's just the way it is being practiced, the form that it can take. Like now we are having ODR, which is online dispute solution. People are now implementing that. So, but you don't go and say that it is a type of ADR. It is one of the formats in which people can offer services or ADR services to the general public. Then there was another thing you mentioned about the arbitration process. I think you outlined certain processes and you mentioned that the arbitration agreement to arbitrate, then you move on to selection of arbitrators. I think you left a key thing there because once there is an agreement to arbitrate, after a dispute has arisen between the parties, there is a need for you to initiate the process. So, and the initiation comes in two formats. Whether your agreement specify for what we call ad hoc arbitration, it means that the parties did not specify a specific institution to handle the arbitration process for them. So it is going to be party driven. Parties are now going to drive the process in initiating the process, sending notification to the other party, and also making sure that they appoint their own or select their own arbitrators to start the process. So you must look at the balance, how those things are, so that you don't confuse that and you don't start from agreement to arbitrate and go and appoint arbitrators straight away. You must initiate the process. So when it comes to arbitration, every arbitration is governed by rules. Either the parties develop their own rules or they find themselves under existing rule that they will use in managing the process. Similar to what happened at the court. Every court has its own rules and how you can go to them. So if the arbitration agreement or the agreement to arbitrate specify that parties are supposed to use institutional arbitration, then it means that you are going under that institution. So if you are using, for instance, SHATI or the African Center for Collaborative Dispute Resolution, then it means that you are going to use our rule. So our rule is going to be the rule which will govern the process, the procedure, how things should be done, how the filing should be done, and what number of days should the other person respond, and all that. Those are the things that I'm talking about. Before the moment you initiate the process, before the selection of the arbitrators or the appointment will come, then the other processes will follow. In other institutions, the parties may even have preliminary meeting before the appointment of the arbitrator. Mostly when it is ad hoc arbitration, parties may have to do a preliminary meeting to discuss certain matters before the appointment of the arbitrators. Then other organizations too require that the parties must meet before the appointment of the arbitrators. Then after they have appointed the arbitrators, certain laws, for instance, if you come to Ghana, the Ghana law mandates that you must do what we call arbitration management conference. So in the same way, you have to look at your law or the rules that you have selected for your arbitration. Does it require that you go according to the number of days, or what are you supposed to do? So please check that one again. Then the second presenter talking about conciliation. When you are talking about conciliation and you say that it is not binding, or the outcome of conciliation is not binding, I have an issue there. If the outcome is signed by both parties, so that means that we have an outcome. So the moment you have an outcome, it means that both parties have agreed on mutually terms and they have signed to that. So it means that they have an outcome. If they don't sign anything, it means that there's no outcome. So the outcome that the parties have signed is binding. So you cannot say it is not binding. It is, we normally refer to as a non-binding process. So it is the process that is not binding, not the outcome. Because parties may choose to walk away at any time, unlike arbitration. Because arbitration, the moment you conduct the initial processes and appoint the arbitrators run the process like the court process, similar to that. So you cannot say that you are withdrawing from the process. But conciliation, you can. Like mediation, you can also do same until a terms of settlement has been agreed upon by the parties and the parties have signed. Then it means that parties cannot run away from it. So it becomes binding. So please note that too. You hear a lot of people talking about it's not binding, it's not binding, it's not binding. But we talk about the process. It is a process that is non-binding process, because parties attend or commit to those processes out of their own volition, and they go it without anybody coercing them to go through the process. And that is what I want you to take note of. Then there's another person also mentioned the negotiation process. He said planning and yes, and planning. As part of your planning, yes, you must also look at what kind of negotiation are you going to do. So I was expecting to see types of negotiation, whether integrative or distributive. Integrative means that it's interest-based negotiation. You don't look at only your interest, but you're looking at the interest of the whole. But and then we have distributive negotiation as well, which is based on win-lose. I must win. So sometimes somebody can price a car as higher, and somebody will say that, oh, I'll give you this. Sometimes based on the price that you give, the person may say that they have won or they have won. Then we normally buy a lot. You do negotiation. I think the person mentioned that negotiation happen in certain areas. Everyone does negotiation. It doesn't matter the field that you find yourself within. Negotiation is everywhere. We do it everywhere. Everywhere we do negotiation. So it's daily life. Then and defining mediation too, you mentioned that the mediation is a process that is conducted outside the court, which is being settled by a mediator or a third party to assist parties outside the court. So my question was, if you say outside the court, what if it is a court annexed mediation? So what if the court is the one that ordered for the mediation or even suggested to the parties and they accepted? What if it is that? What will you say? So normally mediation is not just outside the court system. We normally refer to as outside litigation, or instead of using litigation to adjudicate the process, mediation comes in. So instead of using outside the court, it can be outside litigation processes, or it can be a part of a court process system, because you can have your matter in court and the matter can be referred to mediation, either at the request of the parties or depending on the law within your country. A judge can also suggest to the parties and parties can agree and go and use mediation. So my other mentors have also mentioned key points that I want you to take notice of it. Like we say ADR is faster, cost effective. Yes, it is. But when it comes to the cost, mediators also charge. Mediation is not free. So arbitration is not free. And you can also be a negotiator and negotiate on behalf of a company. That is also not free. So all this, we must know how we balance them and understand them critically so that we are able to speak about it well. And this is what I want to say. Thank you, and I wish you the very best. Thank you, Nanchan, for bringing us together.
Thank you, Mr. Isaac. That's wonderful. The other mentors, please, over to you. Baratu, Amina, Omotayo.
Sorry,
Please.
my network just went off. And thank God it is back now. So, can you hear me? Hello?
Can hear you. We can hear you.
Yes, we can. All right. So, my name is Baratu Dangana, and I will sincerely commend the mentees for the industry they put in making this presentation, both Group 1 and Group 2. Wonderful presentation. And the other mentors have mentioned a lot of key things that are to be considered in the general overview of alternative dispute resolution. All those options for resolving disputes that have been mentioned by the mentees are the actual options. Of course, I agree with the last mentor who said that the multi-door courthouse is not a form of mediation, but it's a door to mediation. That's why it is actually attached with the door. It's usually all of these forms of mediation are practiced inside of the multi-door court. So either arbitration or mediation or conciliation, or even the Med app, you mediate, and if parties don't agree, you arbitrate. Now, there are some basic things that I want us to note, especially regarding the mediators. for a mediator to become a mediator, he has to have certain kind of skills which are very, very important. And those skills has to do with he must be a 70% listener and perhaps just 3% or 30% talk during the mediation session. And mediation, arbitration, and all the forms of ADR are party driven. And so the consent of the party, just like we mentioned, is very, very important. But in mediation, even before the commencement of mediation, the parties must sign an agreement. Even the conciliation, once the parties sign an agreement to mediate, then the parties will be bound by the agreement, and the agreement can be enforced because the parties have signed. So it becomes another kind of contract. And also for arbitration, arbitration is a quasi-court because at the end of the day, a judgment is given, which we call an award in arbitration. So, but the bedrock of arbitration is that there should be an arbitration clause, and that arbitration clause is usually signed by the parties. Well, it can be done in any way. It can be in writing. It can be even by SMS. It can be by WhatsApp right now, even Telegram. But once there is consent of the parties, then they are bound to arbitrate on the issues they have agreed to arbitrate. Perhaps they entered into a contract, and now, because of disputes that have arisen from the contract, they have already stated that once there is any dispute from this our contract, we have agreed to arbitrate. Now, in those agreements, there are some basic things that must be there. Now, the parties will have to be clear what kind of arbitrator they want. If they don't agree, then the provisions of the law of the country will come in. For instance, in their arbitration agreement, they should agree whether they want a tribunal of 3 arbitrators or a one-person arbitrator. So if they agreed, it makes it easier. But if they just said it should be by arbitration, then it is the, maybe for instance, Nigeria, then it is the Arbitration and Mediation Act that will take precedence. And generally, all of these mechanisms for resolving disputes are mostly effective only when the parties have given them power. But if the parties did not give power to these forms of mechanisms enforced, no matter how beautiful it appears, if the parties, in fact, in mediation, there is even an opportunity to tell the parties to withdraw, that they can withdraw. If after you have commenced mediation and the parties feels that they don't want to continue, they can withdraw. So there is no compulsion in this alternative dispute resolution. But like we said, all the advantages are true. It saves a lot of time. Well, the cost part of it is relative. It depends on how much is involved or the dispute itself. And then also, one point I want to make is in the idea of ethics in all of this dispute resolution mechanism. For the mediator, there has to be some ethical consideration. Even for the arbitrators, there has to be some ethical consideration because integrity is what is very, very important in all of these alternative dispute resolution mechanisms. So once the parties are not settled on either the mediator or the arbitrator, it means whatever outcome will come out will not be effective because they have some integrity question on the mediator or on the arbitrator. So the arbitrators and the mediators must have ethics to guide them generally in resolving and determining any kind of dispute that comes before them. And then at the end, I want to conclude to say that in mediation, it is very, very important that the parties know that once they reach an agreement, that is a settlement agreement or a mediated settlement agreement, then it becomes binding on them. So that idea of saying because it is mediation it's not binding, or because it is conciliation it's not binding, goes away once the parties have agreed. Now, the agreement is usually at the very beginning of the mediation. And that's why mediators are warned not to commence mediation without asking the parties to consent to the mediation. So for now, I think I will want to stop so far so that other mentors can come in. Thank you.
Thank you very much, Baratu, for that wonderful contribution. So, Omotayo.
Good evening, all. I want to commend the mentees for the industry they put in the presentation. Is actually a worthwhile one. I also appreciate fellow mentors. In fact, I will say that you have all said it all, but at least let me also mention 2 points in addition to what fellow mentors have mentioned. I noticed that while the group that discussed negotiation, while the presenter was presenting, he made mention of active listening. That steps in negotiation. I think the third one, that's discussion phase. Then he said active listening. So I was expecting that maybe the presenter will go forward to explain what active listening is, because it's actually very, very important in ADR, even in not only in negotiation, in mediation. And I think the last mentor that just spoke mentioned that it means maybe like paying attention 70%, you talk less. So when we talk about active listening, we are saying you are listening to understand what they are saying. What is it that you are listening, not to respond, but rather maybe to the negotiation, to the other party. And then in mediation, the mediator is actually listening to understand the underlying problems. Because sometimes the problem or the issue that is even brought might not be the problem. But when you listen very well, then you can see the problems that are beneath, that are actually the cause that need to be treated. So that is active listening. So we need to pay attention to that, because it's very, very important if we want to resolve issues as ADR practitioners. And then there's also under mediation, while discussing is the disadvantage of mediation, the third point, it says that mediation, one of the disadvantages that is dependent on mediator. I differ from that, because just as fellow mentors have mentioned, that mediation is party driven. So the mediator does not even have the power or the authority to make decision for them, for the parties. Rather, the mediator only facilitates the discussion and help them to reach agreement. So we cannot say that mediation is dependent on mediator. Rather, it is the parties. A mediator is only helping the parties to reach an agreement so that they can solve whatever problems that they have actually brought to the mediation table. So, as I've said earlier, fellow mentors have mentioned most of the points I want to discuss, but I say let me just mention these two. So I must commend and congratulate the mentees once again, and I also appreciate the comments of the mentors too. We are all gaining value. Thank you very much.
All right, thank you, Omotayo, for that contribution. Mr. Babajide Adams.
I'm with you, please. Good evening, everyone. Can you hear me? Okay. All right. My name is Babajide Adams. I first of all want to appreciate all the mentees. They really did a good job. While I was listening to them, I almost forgot that they were mentees. I mean, even though it was short, but at least they spoke to the paper and to the presentation. I really appreciate them for that. So they took us through what is meditation, which is basically a neutral trying to resolve disputes between parties. So the neutral basically is trying to facilitate both parties to discuss settlements, if I may put it that way. So the agreement that both parties agree on at the end of the day it's going to be party driven. So the mediator basically helps parties to resolve their disputes. While conciliation used to be very powerful in the formal acts, that is during the ACA, but now it has been repealed by the AMA. So during the ACA, conciliation was a big thing, and basically conciliation is used during labor dispute and things like that. But right now we look at arbitration, and that is what is entailed in the new act, which is the Arbitration and Mediation Act. And so we come to see arbitrators. We come to see mediation and conciliation, like one of the mentors have said. All the definition of mediation applies to conciliation as well. Now, when we look at negotiation, basically it's between parties. This does not have a third party, except maybe when one of them in a multinational, where because it could happen where a negotiator, a professional negotiator or an experienced negotiator or an expert is asked to mediate on behalf of parties. So you see the party there and a negotiator negotiating on behalf of his clients because of the skill sets that he has. So he's bringing to the table his years of experience to make sure that his clients or those he represents get a better deal. And it will be very important for the other party as well to come to the when you are aware that the person you're going to negotiate on with is coming with an expert or is coming with a professional, then it is advisable that you do the same so as not to lose the balance, because negotiation can be very tactical, it can be very emotional, and there are skills that applies to it. You hear people saying certain things. Please do not take those words for granted. It might be the negotiator trying to bring you to himself, and so once you fall into that web, you gets more advantage than it gets more advantageous than the other party. Just like one of the mentors has mentioned that is it going to be distributive or interest based, and so it's very important that when it comes to the negotiation table, we come with a negotiator as well that could help parties. And so by and large, I want to say that the mentees did a good job and the mentors have covered a lot of ground. I really appreciate you all and kudos to the organizers of this program. Thank you. Well done and God bless.
All right, thank you, Mr. Babajide, for that wonderful contribution. Let's go to mentees to ask their question. If there's anyone who has question, please put it forward before we conclude.
Hello everyone. Sorry, we'll be taking questions right about now. We've had our mentors give comments to the presentations that were made, and share other perspective as regards what we have been doing. So please, if you have questions, specific questions that you would like to ask as regards the discourse and particular things that they have shared, right? Please do well to indicate by the raise of hands, and we'll do well to give you the opportunity to ask your questions. But while we are waiting for questions, some questions were sent. Okay, I can see someone raising their hand. Please, if you are, you can go ahead and unmute. Then after we've taken live questions, then we'll go ahead to read the questions on the chat box. Please, you can go ahead and ask your question.
Thank you very much. Let me confirm that everybody can hear me.
All right, we can all hear you, Mr. Jason.
All right, thank you, Dennis. Thank you very much to the mentors. I learned so much today, and I'm looking forward to carrying this as an area of practice. So I have a question. One of the mentors mentioned that unlike the textbook ideas of ADR, that it's not as cost effective, and he said that it's possible that an arbitrator would charge like 30 million. So I want to find out if there is kind of a schedule for charges of we who want to go into this ADR mechanism, like personally me that wants to be an arbitrator. So is there like a schedule, or I'm free to charge as I will? Just to understand how cost effective it can be or how not. I hope you understand the question. Thank you very much.
Okay, thank you very much, Jason, for your question. We'll be having this more like an open dialogue, right? So any mentor that would like to comment on the question that was asked, please, you can go ahead and just go ahead and speak to the questions that were given. So please, do we have any mentor in class who would like to comment on the question that was asked?
I think the arbitrator cannot just charge just like that. Usually the parties agree on the fee to pay the arbitrator. And it's the main consideration is how much is involved in the arbitration, or the worth of what is involved in the arbitration. And so for the two parties are the ones to contribute to what will make up the fee of the arbitrator. And those fees also will have to include administrative fee, the secretariat fee, and the rest of the other things. Even the venue, if it has to be paid for, it will be included in the fee. So the arbitrator does not just come and say, this is how much you must pay me, but the parties will agree on how much will be paid to arbitrator. And the two parties usually bear the cost of paying the arbitrator. Thank you.
All right.
Okay, thank you very much. I understand.
All right, thank you, Ms. Baratu, for helping us sort that question. We can see more people with their hands up. Please, you can go ahead.
Want to add, charging for arbitration depends on whether it is institutional arbitration or ad hoc arbitration. Do I have any mentor in the house who will give us a highlight of how it is, if it is ad hoc or institutional arbitration?
Yes, the institutional arbitration is wherein an organization is the one paying the arbitrator. For instance, in Nigeria, we have institutions like NICAP. We also have institutions like the Settlement House. So if they are the ones who appointed the arbitrator, they will be responsible for charging the parties and they will take care of all the other costs. But the amount to be given to the arbitrator will be decided by the institution. But wherein it is ad hoc arbitration, that is where the arbitrator himself will collect or we get a fee or earn a fee from the arbitration directly from the party since he is not passing through an institution. Thank you.
All
Okay,
right.
thank
Thank
you.
you very
Thank you very I want to add some few things to the institutional one. So when it comes to institutional and ad hoc arbitration, there are few technical issues that people should look at for such that institution like ICC, when you submit your arbitration there, they have a scale of fees. So every institution has a scale of fees that they use. So before you even submit your matter there, you know the amount that the institution is going to charge you and the filing fee that you're going to pay. In most arbitration institutions, your filing is not complete until you have paid your filing fee and also the fees that they will charge you. If you look at the schedule of fees, you will see it there. Then again, when it comes to the institutional arbitration, as I use ICC as an example, when you finish the arbitration as a tribunal, it goes back to the ICC for a review before the award will be released to the parties. So there is a review added to it. But when it comes to ad hoc, it is straight from the arbitrators after the award has been given straight to the parties. There is no review or nobody has any supervision over the tribunal. So you yourself have set up your own tribunal to render an award for you, and that's it. So that is how it is. Thank you.
All right. Thank you so much, Mr. Isaac, and thank you, Ms. Barasu, for helping us deal with that question. I can see we have two people raising their hands. We'll start firstly with Nadia and then go to Salma. So Nadia, please go ahead and ask your question.
Thank you very much. Good evening, everyone. Thank you for giving us the opportunity to learn. So my question is, during the course of my research, I noticed that conciliation and mediation are very much alike. So please, I want to know the key difference between the two. Thank you.
All right. Thank you very much for your question. Do we have any mentor who would like to answer that? Okay, can we all hear me?
Yes, we can hear you.
We can hear.
Oh, all right. Please, over to our mentors. Nadia is trying to ask the difference, the major or the key difference between, did she say mediation and conciliation, if I'm not mistaken, right? Yeah, she's trying to find out the key difference between both.
Okay. So mediation and conciliation, they are all third party. They are all ways or means of resolving disputes, right? They are mechanisms for resolving disputes. So while mediation involves also the appointment of a third party neutral, the conciliation also involves the appointment of a third party neutral. So, but in mediation, the mediator is impartial, is neutral.
and it does not suggest solutions to parties. On the other hand, a conciliator makes suggestion as to the solution. He can make suggestion as to the solution, for the parties, but subject to their ratification. So, in a nutshell, if you look at AMA, the Arbitration and Mediation Act of 2023, if you look at the definition, both mediation, conciliation, or any other alternative way of resolving disputes that does not require either the mediator or conciliator or whatsoever name the person is called, as long as he does not have the power to impose a solution on the parties, that process is called mediation. So in essence, both mediation and conciliation are actually the same thing, except for the fact that, in fact, in the amendments, they said mediation involves a process where a third party neutral is appointed. It facilitates the discussion and can make suggestions. It can make proposals as to solution to the parties, but subject to the parties' approval. So if you look at the new act, there will be no difference between mediation and conciliation, as far as the mediator or the conciliator or whatsoever name the person is called does not have the power to impose a solution or a proposal on the parties. So the parties are the ones that have the final say. So I think that is basically the difference between them. But as it stands now in Nigeria with the amendment, there is actually no difference, so to say, except the emphasis is that the third party neutral that is appointed, whatsoever name the person is being given, he does not have the power to impose any solution on the parties. He can make suggestions to them, and the parties may decide to accept the solution. And if they accept the solution or the proposal, then it becomes binding on them. But unlike arbitration, the parties, the arbitrator can make an award, and that award is binding. So you see, that's imposition of a solution. I don't know if I've addressed your question.
Yes, sir, we did. Thank you very much. Thank you so much.
Thank you very much, Mr. Nyacham, and thank you also, Nadia, for your question. We'll be moving on. Salma, please, you can go and ask your question.
All right, good evening, everybody. Please, during the course of the discussion, one of the mentors mentioned the two types of negotiation. So I didn't get that clearly.
Okay.
Okay, I think I'm the one who mentioned that. I mentioned integrative negotiation, which I said it is the same as what we call interest-based negotiation, or distributive negotiation, which is also referred to as win-lose negotiation. So that is what I mentioned. I hope you have gotten it now. Thank you.
Thank
All
you
right.
very much.
Thank you, Mr. Isaac, for clearing that out. All right, so we'll be taking questions from. Okay, please, who is iPhone 01? Sorry. Please, can you kindly rename yourself so that we get to know you by name? All right, but you can go ahead and ask your question.
Thank you very much. Good evening, sir.
Yes, good
My
evening.
name is Hashim Misauban. I didn't edit the name before I joined the call this evening, so I'm Really sorry for that. So my question is based on the presentation from Group 2. I noted something about their presentation where it was mentioned under the disadvantages of conciliation. It was explicitly stated there that it does not have any precedent, with explanation that it does not have any, does not contribute to legal development, nor does it has any consistency. So my question, to be precise, is in what sense does conciliation does not contribute to legal development, and how it is inconsistent for them to arrive at that conclusion? Thank you very much, sir.
All right.
So, well, for that question, you see, I think what they are trying to say is that, if you look at, are you a law student or are you a lawyer?
I am a law student, sir, University of Ilorin.
Okay, so you see, in law, there is this principle of stare decisis. That's the doctrine of precedent. That when a superior court gives a judgment or a ruling, it binds the one below it, right? So for you to be able to make reference to a particular decision, that decision must have a binding force. And if it has a binding force, and it's, let's say, for example, a decision of the Supreme Court, which is reported and is made available to the public, that becomes a precedent for the Court of Appeal and the High Court, including the lower courts, magistrates, customary courts, Sharia courts, among others. So, because of that principles of precedent, rulings are made, and then they are published either in law reports or you get certified through copies. But when it comes to ADR, there is this principle of confidentiality. And when you talk of confidentiality, it means that whatsoever happens at the mediation table, including the settlement or the decision that is reached and agreed upon by the parties, is private, is personal, is confidential, and would not be made available. So if you have a situation like that, you cannot in ADR have a situation where you can have binding precedents, because first, the decisions or the agreement of parties are considered confidential. Their discussions are without prejudice, and you cannot make it available to the public until the parties so agree. So you cannot make reference to it and say, in the dispute between so person and so person is similar case, similar subject matter, similar disputes and similar whatsoever, and this is how it was decided. So why are we departing here? So in conciliation and mediation, somebody can bring a matter to court for recovery of, let's say, 10,000 naira. At the end of it, parties may agree and say, okay, I do not have money to give you. But since I don't have money to give you, but I have a good that is worth the amount you are asking for, even much more than that. So can you take the goat? And the person will say, oh, yes, in fact, I like goat meat. Please give it to me. So you see that somebody can start a dispute requesting for refund of money or claiming damages in form of money, and at the end of it, it will end up in a different thing. Somebody can say, okay, I even forgive you. Just give me, let's say, something of 10,000 naira. I can say, just give me 5,000 naira and we are good to go. So you see, in that situation, you can never have a precedent. And even if there is any possibility, whatsoever is decided is private and confidential, and it's not meant for public consumption. So there is no way you can make reference to it under the doctrine of precedent. So that is why I think they are making reference, they are saying that it does not contribute to the development of the law. As you know, if, for example, the Supreme Court have decided something on similar, let's say, elements for you to prove to establish the offense of murder, and then another matter came up again before the Supreme Court, and the Court of Appeal has decided a matter, for example, and say that, okay, you must prove actus reus, and then there must be mens rea, and then there must be the meeting of the actus reus and the mens rea before you can establish a criminal offense. So when there is an appeal from the Court of Appeal to the Supreme Court, or another similar case goes to the Supreme Court, and the Supreme Court diverted from that position of the Court of Appeal, that current decision of the Supreme Court becomes the binding precedent and contributed to the development of knowledge, development of the law. But that is not obtainable in ADR, so to say, except maybe in arbitration, where matters, the parties allow that their matters be reported, and then you have them reported, and then they can be made reference, as precedents. I don't know if you understand me.
Yes, sir. That's well understood, sir. I really appreciate the response, sir.
All right. Thank you so much, Mr. Nyacham. Thank you to the person who asked. So we have, okay, so we'll be taking 3 more questions from the live questions, and then we'll go straight to the questions on the chat box so that we can stay within the time frame allocated for the class. Will be question from
Sorry,
Ishim.
Mr. Dennis, can I? Okay, sorry.
Okay, Ms. Omosaya, please, you can go ahead and speak if you want to.
Okay, sir. Thank you. Sir, I just wanted to add to what Mr. Nanchan just said. When we say we are developing the law, then there is room for criticizing a particular decision. That this particular decision that was reached by maybe the Supreme Court, that is not supposed to be like this. But there has to be record for the public to see. There has to be record that, oh, what happened in this case is different from this, or they are similar. Then when such criticism are coming, then the law will develop. And that's why we have situations where even the Supreme Court usually usually go back on their decisions. So they say, okay, because of the criticism that are coming, they look at it again and they now say, this is not supposed to be so. Then we are developing the law. But just as he said, or immediation like that, these things are confidential. You can't even bring out the document. A mediator cannot even be forced to come and testify as to what happened. So it's not made available to the public. And if that is the case, there cannot be room to criticize it, that no, this is not supposed to be so, this is not supposed to be so. And that is why we can say it's not helping in developing our laws. So that is why you see that some maybe decisions that were taken years back, because of maybe human rights activism and criticism, you see that even the court itself is going back that no, we were not supposed to have decided it this way, or going forward, we're going to do it this. Opportunity is not available in mediation because it is confidential and everything hence on the mediation table. Thank you.
Thank you so much, Ms. Omotayo. We'll be taking question from Ishim. Sorry if I did not pronounce your name very well, but please, you can go ahead and ask your question. Ishim Nkadi.
All right. Good evening.
Yes, all right. Well, please, can you help me like with the pronunciation of your name so that I don't smother it next time?
My name is Aishim Kadi.
Oh, all right. So sorry for my pronunciation.
No problem, sir. Thank you very much. Thank you so much for this wonderful opportunity. So my question is this: is ADR for like certain types of disputes? Because I think the second mentor said something that is not. It doesn't bother on just litigation. So is it for like certain types of disputes like commercial law, family, labor, and all of that? And if yes, why is it that many persons are not opting for ADR if it's more time, if it preserves more time, and if it's... Hello, can you hear me?
Your network was breaking, but we
Can you
can
hear...
hear you now. Yeah, we can hear you now.
Oh, sorry.
Hello.
Hello, can you hear me?
Yes, your network is it's season, it's going off and on. So please, can you like come again with the last part of your question?
Okay. I said if ADR preserves more time, and although it's costly, so also is going to court also costly. Like, why don't people opt in for ADR more instead of just going to court? Because there are a lot of cases in court that they are just piling up, and
I think let
it
me
doesn't
just quickly
depend on the...
to
Since they said, sorry, since they said it
Um,
doesn't just depend on the arbitrator or the mediator, that it depends on the parties. So if the parties just agree and they just decide that, oh, this is what we're going to do, so why don't most people opt in for ADR instead of just going to court? Since ADR is faster, and even though it's costly, but it's not, I don't think it's as costly as going to court.
all right, thank you for your question. I think Ms. Barroso was trying to answer your question. Over to you.
Before she answered, I think the reason why people may not go for ADR first is because of ignorance, and many people are not aware. As you know that when there is a dispute, what people know, if there is an issue between parties, what they know is to go to court or to go to the police. And that is why JIIPCC and Settlement House ADR Training Institute has brought up this training for free as its own way of contributing to the education and creating the awareness on ADR and the processes. So you are a beneficiary of this so that you don't just keep it to yourself. You let other people get to know that, okay, next session, there is going to be an ADR session. When you get enlightened, you are in a better position to enlighten others and to guide them when they have their disputes and their issues, so that they can opt for ADR. So you can do that in the mosque, you can do that in the church, you can do that in the community, can do that in the workplace. So we are training you to become ambassadors of ADR, so that anywhere you find yourself, if there is a dispute, you guide the people and direct them on where they can find solution. But where there is ignorance, people don't know what to do. You see, that would be a serious problem. So this training is part of an awareness. This mentorship is part of an awareness that is made available to you and to other mentees, so that you can also be educated in this aspect. And in addition, ADR is actually for certain types of disputes. Not all types of disputes are arbitrable, ADR inclined. So, for example, criminal offenses, especially capital offenses, because we have restorative justice that deals with for some forms of mediation when it comes to criminal matters, in simple offenses of that nature, but majorly the ADR applies to civil cases, civil matters, more especially where the parties have a say in the settlement, or they have a say in the outcome of their dispute. But if you commit a criminal offense, for example, even if let's say you even if the victim of the crime decides to say, I've forgiven you. You stole something from someone and the owner says, okay, I've forgiven him since I've recovered my property. That notwithstanding, the police can still say that we are going to prosecute, because offenses are generally against the state and against the public, and not just a particular individual. That individual is a victim. That's understandable. So, but then it's against the state, and the state can decide to prosecute you even if the person who you offended or committed the sin against, decides to forgive you. So you see, ADR applies in commercial and civil transactions where the parties can decide to say, oh, I've let go of this thing. And once they say they let go, nobody can say you must come and prosecute. You must take up this matter. But if it is criminal inclined, so that's one of the things that I see that it has not been included in the overview presented by both parties. Are all disputes either arbitrable or mediatable? So I think that is it. Then please, Baratu, you wanted to say something.
I think you've basically said what I wanted to say. And another thing why people don't go for ADR, aside from the fact that many people are not aware, and this is an opportunity for creating awareness, is that some people just use ego to settle disputes. I want to show them. And one of the ways they show people who they are is by taking the issue to the police or going to court. So, but now that we are aware that indeed ADR is a more better way of handling conflict, I think we can be ambassadors in all our communities to ensure that people don't go through the stress of litigation, which can take years before you will get the fruits of what you are looking for, and opt for ADR instead, which you can settle even in a day. Certain cases can be settled that could take years in court. So I think the reasons you have advanced are the reasons I also wanted to talk about. Thank you.
All right. Thank you so much, Ms. Baratu.
You see, landlord and tenants disputes, commercial disputes, family disputes, and all these kind of private kind of disputes are disputes that are suitable for ADR. So that, one of the advantages is that you can resolve your dispute and continue doing your business. But when you go to court, for example, and one person is declared a winner, the other person will feel that his own side of the story is either misunderstood by the judge or the judge is bribed. So I am going to appeal against it. So you need to know that one of the catchment area for ADR is the fact that it is the parties that make the decision. And once the parties make the decision, they tend to abide by it without necessarily going for enforcement, especially in mediation. Arbitration, a third party decides for you. So by mediation, parties are the one who craft the solution for themselves. So you see that becomes easier for them to abide by what they have decided for themselves. They own it, so it helps in ease of bringing solution, and you have multiple options. You can start with one, claiming one thing. Remember in court, they said that the court is not a Father Christmas. You can only give you what you ask for. Once you don't ask for something, they will not give you. But in ADR, I can say that ADR is a Father Christmas because it can give you what you did not even ask for. You can start claiming money and you end up getting maybe goods, you get peace, you can get forgiveness, you can get many other things. There are variety of options. So those are some of the issues that you can see. Business inclined, matters that are business, commercial minded, but there are issues that has to do with public policy of a country or matters that are illegal. If, for example, you said someone should supply you, let's say, like 5 prostitutes, or so that you can take them out of the country. And then after you agreed, you paid money, and then the person fails to bring it. They say, I'm going to go and arbitrate this matter, I'm going to go and mediate it. You see, that contract on its own is illegal. Or you say, armed robbers are disturbing me in my area, please, we need you to supply me, I need you to supply me 5 AK-47, and they are not licensed. The person collected the money and then just disappears. You keep calling and calling, and then you say, I'll go for mediation, I'll go for arbitration. Those things are first illegal, they are contrary to public policies, so it's not something you can go to court, so to say, to even enforce, not to say you are going for arbitration or for mediation. So these are some of the matters. So generally, it's not all disputes that are arbitrable. Criminal matters against public policy, matters that expressly are against the provisions of law. These are matters that you cannot arbitrate, you cannot do ADR, you cannot do mediation or negotiate about. They are outrightly illegal and cannot be attended to. But matters that has to do with your business, has to do with your personal thing, something that you can decide to say, I'll let go, you have a say in it, these are things that you can mediate. These are types of disputes that you can mediate. So it includes your family issues, your business issue, commercial issue, landlord and tenant, evasion, contracts, plenty. They are so numerous, construction disputes, all manner of things. And these are some of the things that were not listed in some of the presentation. But thank God it's coming up now so that we can all take note. I expect that every mentee should have a book where you write almost everything that we are discussing here, because if you don't write them down, before you have opportunity of getting insight of some of these things, sometimes until you go for a formalized training, and not the training may just be maybe in the first cadre of associate, you may not get it until you get to membership or fellowship. So, but here you can be able to get almost everything. So please, you need to research, get some things that you need to bring to the mentorship session and ask questions for clarification. And you have mentors who are here and available to answer you. Thank you very much.
Thank you, sir.
Thank you very much, Mr. Nyasham, and thank you for your question. So we'll take the last 2 questions quickly, and then we'll go to the questions in chat box. Esther, please, you can go ahead and ask your question.
Good afternoon, good evening, everyone. My name is Oluwaseun. Thank you so much to the mentors for committing their time and their resources to this class. I actually have more than one question, but I would put them together so that any mentor that wants to respond can respond to them together or independently. So my first question is that I am a law graduate, and we lawyers, under the rules of professional conduct in Nigeria, are not allowed to advertise their services. So I wanted to ask if it is possible for ADR experts to advertise their services. Is it possible for me to talk about what I do, or the fact that I am an alternative dispute resolution expert online or in person? Second question is, can I act as an independent ADR expert, or do I have to be attached to a professional organization? When I was in university, I took a course with a professional body in Nigeria that offers ADR um, courses. And after we were certified, after graduation, one of the things I noticed was that in my state, I was told that the before you can join the branch of that body in my state, I live in the southwest part of Nigeria, and I was told that before I can join that body, before I can be a part of or be a member of that branch of the body, I have to be a lawyer first. And I was very confused because I understand that we were also taught that you don't have to be a lawyer to be an ADR expert, and it's not a course or it's not a line of profession that is solely for lawyers only. That there are people from other professional courses too that can take that can become ADR experts. And so I just wanted to ask, do I have to be attached to an organization or can I practice independently? My third question is that if the proceedings are private, if proceedings of alternative dispute resolution systems are private, how can students or ADR enthusiasts learn from practical real life scenarios? Because when I was making the research for my group presentation, for our group presentation, I noticed that I could not find so many case studies. And the same thing also happened the first time I took this course. And so I just wanted to ask, is there like a system for students or enthusiasts or professionals to access proceedings of ADR cases? For example, in for law students, I know that we have the Nigerian weekly law reports. We have things like we have applications like Law Pavilion, Case Radar, things that we can places where we can go to find cases, to find real life cases, because law is very practical. So if these proceedings are private, how can I, as a student, immerse myself into the practicality of the entire system? Those are my three questions. Thank you so much.
All right. Thank you very much, Esther, for your question.
I need to drink what after answering this your question.
Okay, I think let me answer the first one. Is it that I think one of them was about whether the person should be a lawyer, and the people said that the person has to be a lawyer. I think maybe they got it wrong. You don't need to be a lawyer in most jurisdictions before you can be a mediator. Like I won't be a lawyer, I won't be a mediator. I've been practicing ADR for the past over 10 years now, but I'm not a lawyer. So except the only country that I've seen that only lawyers are certified to become mediators is Turkey. That's the only place that if you are not a lawyer, you can be a mediator. That's the only place in the world. But apart from that, I don't know, maybe there are others. Most countries are liberal, and everyone who has the needed skills can be a mediator, can be arbitrator. There are even certain matters that lawyers cannot even arbitrate. They can be lawyers, but they cannot even arbitrate on such matters because there are technical things that the lawyer may not even understand, judges may not even understand. So they give it to industry experts, so who are trained to adjudicate on such matters, to deliver an award for them. So you don't need to be a lawyer before you can practice, but becoming a lawyer, it gives you certain edge because you understand certain things. But one thing is that if you are a lawyer and you are doing mediation, you don't go with your lawyer jacket. You remove the jacket and put it somewhere, because non-violent mediation is based on non-violent practices. And then if you are talking about non-violent practices, you do away with the law a bit and look at parties' emotions, their feelings, what is important to them, and their interests and their needs. That is what we look at for in mediation. And talking about proceedings, and you want to, I think Nanchan shared earlier that when it comes to ADR, ADR is confidential. The things are supposed to be confidential, and even after the process, none of them is supposed to even share any document or anything with the public, unless the parties agree that you can share my document or information. So it is important for you to know that. That is why there are various institutions with practitioners. When we meet in class, some of the work that we do, sometimes we change the characters and we are able to share with the student that, okay, this is what happens, this is how it is done, this is a sample, this is what you see, so that during those trainings you have the opportunity to see those things. But apart from that, it will not be, or maybe some people can also develop it into such a way that there's something, some of them may put it out there for you to see, but it is not easy to come by an award, or especially with mediation outcomes, you may not see one. Even sometimes because of politics and other things, you may see, or the international nature of arbitration, you may see award online, but it is not easy to even find mediation outcome. You won't see them. Sometimes you may read maybe some of the law reports which has um, ADR outcomes that have been adopted by the court as consent judgment. So you may find the terms of settlement there. If not, you won't see some of them. So it is important for you to understand this thing. And we're talking about advertising or prioritizing or letting people know what you do. Yes, when in most jurisdictions, ADR is fluid, it's fragile. They don't restrict much as they restrict the law practice. So because when it comes to ADR, it's party driven. It's the parties that will see that you as an individual can offer them this kind of services, and they can. So you can have a website, you can have a LinkedIn channel, you can have a Facebook channel, you can talk about ADR. One of the ways to get people to understand what you do is by participating in events like this. You talk about what you learn from those events. You talk about your what you are doing in the industry. You talk about the activities that you have been undertaking in the area of mediation and arbitration, and how these things are helping the society. These are the ways in which you advertise, or you even talk to the public about that on social media. We say lawyers do not, they are not supposed to advertise, but lawyers post. They have almost every lawyer has a Facebook or WhatsApp or LinkedIn platform that they post every day, talking about event that they have attended. They have been invited to serve somewhere. All these things are adverts, but you will not see them saying that bring your case. They are telling you about events and other things that they are doing within the inside article that they have written. All these things are adverts. So these are ways that you can let people know the kind of work that you do. Social media is powerful, but you must use it well. And also attend webinars, attend conferences. Based on that, people get to know you. And I attended programs. That is why I got to know Nanchan. One of our mentor organized. We also went through mentorship. One of our mentor, Vikram, also organized program, and now he's resting. He used to run programs every week, every week, and we used to attend every week. We were with him, learning, asking questions, and meeting top mediators and asking them questions. Michael Lang, Ken Clark, and those people. We met them through those gatherings. So look through the net. You see people advertising for webinars. Some of them are free. Some of them you have to pay. Apply, participate, make time for them. Based on that, you get to get associates, patrons, and other people who find interest in what you are doing. And if you are enthusiastic about what you are doing, they also find time to also assist you. Last year, myself, our organization, and Nanchan Shati, we organized the African Mediation Conference together. And we were lucky to have Michael Lang to serve as the chairperson and Professor Olajide as the keynote speaker. And we had a lot of almost more than 12 speakers across Africa and beyond to speak on mediation matters. These are some of the things that you can do, you can be doing, and make sure that you participate in this event. Based on that, people get to know you. People will not come to your house and get to know you. Social media is free. use it well, and you benefit from them. So thank you.
Thank you very much, Mr. Isaac, for that wonderful contribution. So, Olua Sheung, maybe on your mentorship group, you can chat me up, and then we will talk further. But on some of the questions you have asked, Mr. Isaac has given you a very good response. Just to add that as you are being trained to be a legal practitioner in Nigeria. So you know the rules of professional conduct for legal practitioners clearly identify certain things that you should not do. You should not advertise. And the advertisement is regulated. For example, you are not supposed to have a signboard, a very big signboard like that, and say the best criminal lawyer in Nigeria. Olua, can you put on your camera? Let me be seeing you. Olua Sheung.
Yes, sir, I'm here, sir.
Yes. So, you know, they taught you, maybe when you go to law school, you are going to be taught again that in advertisement, your advertisement is, they didn't say you should not advertise, but your advertisement should be moderate and should be in accordance with the rules of professional conduct. So don't go and have big signboards like, you know, those tellers. You know, when they are advertising, you see billboard, very mighty and big, you know, they will write what they are doing there. You will never see a lawyer signboard like that. So even when you come to his office, you only see maybe a small something, N Nanchang and Co, that's my office, barristers and solicitors, you know, and, you know, notary public or something. That is all, just small size like that. You will not see a signboard that they used to hang on the road, those ones that people used to put. You will see something like that. So even the advertisement, you don't advertise and say maybe you are the best in doing certain things, rendering certain legal services. So, but you see, when you relate with mentors, you get to know. Maybe you can connect with me on LinkedIn if you're on LinkedIn. Sometimes I go to court. I was doing a case with an SN, a criminal matter. I'm defending a client, and then after the court session, they adjourn the matter to like 2-3 months. And I go to my LinkedIn page. I say, today I was in court. Guess what? My matter was adjourned to like 3 months, 2-3 months from now. Say, this is why I love ADR. You know, ADR is fast, is cheap, is dependent on the party. This one, the convenience of the court, the convenience of the learners, the convenience of the other party, all of them join together, they will just adjourn your matter. You know, so I go there. I'm not saying that I'm the best. I'm just trying to help them see that I'm a lawyer. If you read my post, you know that I am a lawyer, but I have more interest in ADR. You know, that's what you're going to see there. I'm not going to say that I am the best something like that. No. You know, so I said, oh, let's say a judgment is given. You go to your LinkedIn page and say, oh, today I went to court, you know, a matter lasted for like 2-3 years, and then a judgment was delivered. And the judgment was delivered against my client, and I'm making preparation to appeal against it. Then you say, but come to think of it, in ADR, once party agree and their terms of settlement has been adopted as a consent judgment, then the parties cannot appeal against it. Don't you see that as an advantage and something that you should take advantage of? You see, when you do that, you know you are not advertising, but you are passing a message. Someone who reads your post will be able to understand, you will get to know something, you know. And so the social media has a way of presenting expert. If you are looking for expert in certain fields, when they filter all your posts and your presentation for some years now, they will be able to analyze it and place you where you belong to. So you don't need to, when it comes to advertisement, you don't need to. So generally, mediators are allowed to, they are not restricted from advertising, but you don't go and be advertising, I'm a best mediator in town, please appoint me. No. That you don't do that. But what you do, you talk about what you do, talk about the area of practice you are into. I'm into family mediation, I'm into, like if you read our profile, you see that when they read it, you see that we say some of us are negotiators, professional negotiators. Some of us are medical law experts. Some of us are this and that. You can do that. You can talk about the profession. People will get to know you, and you attend events, attend mentorship. You can volunteer, for example, with Shati and say, okay, please, I want to be your personal assistant. For example, oh, I want to be the personal assistant to the executive director, meaning that some of the things that I'm going to be doing, I may say, okay, Oluwato, I want to do this thing. Can you help me draft this? Can you help me do this? Can you help me do this? That gives you an opportunity to get to see and hear things that, others may not have the privilege or the opportunity of hearing or seeing. So when an event is coming up, we have a training. Like we have a training coming up in October. Settlement House ADR Training Institute is collaborating with the Kaduna State Multi-Door Courthouse, and we are doing a certification program training on mediation skills training and certification. So in a training like that, if it is virtual and you have the opportunity to attend virtually and you are a mentee or you are a volunteer or you are a personal assistant to the director or to myself, you have opportunity to attend meetings and programs like this, So, and then if you are in a state where there are multi-door courthouses, if you are trained as an ADR practitioner, what you go to do, you go there and say you are a trained mediator for social institution. You want an opportunity to be able to observe. Because of the confidential nature, if they are going to give you that opportunity, they are going to seek the consent of the parties in the dispute to say, okay, we have some mentee, like during the settlement week that we organized in Kaduna State, different ADR organizations and stakeholders come together to make it a success. So you have people who are trained, but they don't have the experience. You see a lot of them, some of them are interns in the multi-door courthouse. So when they come, when there is a session, they will send someone and say, okay, this is a mentee, is a mentee, is an intern. Allow him to stay in the proceeding to see and watch practically how the process is being conducted, So, but if you are waiting for it to be reported on law reports or some of those ADR law report and the rest, you will not see, but that's an opportunity. If you know an ADR practitioner, you go to him, in arbitration, you have tribunal secretaries. With time, we are going to start our training on tribunal secretaries. It gives you opportunity if you are appointed as a secretary or you volunteer, say, please, sir, if you have any arbitration appointment, I'm willing to serve as either the registrar or secretary. Even if you are not going to pay me, I just want to have first-hand information and experience on how the thing is being conducted. So when you have senior colleagues, senior friends who are into these things, and you spray your feathers like that, you see you have opportunity to be able to learn and see how some of the things are being done. By the time you attend 1, 2, 3, or 4, that will go a long way. And then attending trainings. Some people feel that, when you ask some people, you want to be an ADR person, they ask you, where did you train? Say, oh, I am trained with Shati. I'm a Shati certified mediator. And when you become Shati certified mediator, that is all. You don't go and take courses in other institutions. You don't attend webinars. You don't attend professional development. You don't attend anything. Say, no, I'm a mediator. Which some of us who are mediators, because we are specializing in this thing, have attended trainings by Institute of Chartered Mediators and Conciliators. I've attended trainings by Mediation Training Institute, that's in Nigeria. I've attended training from Lagos Multi-Door Courthouse. I've attended training by Kaduna Multi-Door Courthouse. I've attended training by Nigerian Chamber of Commerce. I've attended trainings in Nigeria Institute of Chartered Arbitrators. In fact, I'm a faculty member. So I do a lot of things. When you see my profile and you see the certification I've acquired from different institutions and organizations, ADR organizations, both within Nigeria and out of Nigeria, you can't but say that, oh yes, this person actually is an ADR expert. You cannot just go and stay in just one institution, say I'm a certified mediator, I'm an arbitrator, just in one institution, and you feel, no institution is going to give you all that you need. If you have the ability, you have the resources, you have to go to different institutions, acquire those certifications, get to understand how things are done differently. Sometimes what makes us who we are, is the number of trainings that we have attended. We have had experience in different organizations and training institutions. So it exposes us to more and more things. So so it positions you to be an expert in that field. And you don't need to sit down because they say no, you have to be a lawyer. If it is in Nigeria, I've not seen any of those laws. But sometimes they may be saying, where are you trained? Which place did you train with? And all of those things, all this colonization that we have, they say you have to be trained by so institution before and all of those things. So reach out to the institution that you are trained with, network with. In fact, you don't even need certificate. That's the funny thing. You don't need any certification to be a mediator. You can have the ability, instinct right inside of you. You can have the ability inborn. What we do when we come to training is skill enhancement and development. We are not training you to become a mediator. We are training you. Sometimes some of the things we are training you, sometimes you are even doing it, but you don't know that that is what you're actually doing. And then you now have professional placement of terms, and in a particular situation, so this is a display of emotion. This is at this juncture, I need to do this and that. Because without it, you will lump everything together and you cannot call it either a mediation or a negotiation. So that is one thing that you must learn and understand. It's very, very practical, important. Meanwhile, you can actually practice independently. Yes, you can practice independently. If you're an arbitrator, you can practice independently. If you're a mediator, you can practice independently. The question is, do you have people who know you as an ADR practitioner who can appoint you to help them resolve your dispute? That is the thing. So if you resolve your dispute privately, you can do your terms of settlement and go to any multi-door courthouse. If they say we don't know, you are not going to accept, leave them. Go and file a matter in court. When you file the matter, your terms of settlement annex it to the matter. For a lawyer, that is what is called originating summons, which has to do with interpretation of instrument or construction of instrument. Or you go to a court that has jurisdiction, file a matter, and when you go for mention, come along with your terms of settlement and say parties have settled their dispute, and the court will ask you, you have settled your dispute? Say yes. Say this is our terms of settlement. The court will collect it and confirm from you. If you agree, the court will make that thing as make it consent judgment, and it automatically becomes the judgment of the court. So there is no issue of I have to identify myself with one particular. The identification with organized bodies is that it will make you become more efficient. You can now see how you can practice in a more formalized environment. You get to interact with better, more ADR inclined senior colleagues in the field. That is the essence of all of those things. So but you can practice. So if you are in your community, let the market women know that you are someone who can resolve dispute. Go and volunteer for them, resolve their dispute. Go to your neighborhood. If they have quarrel between one compound or the other, or between neighbor and neighbor, or tenant and tenant, go and resolve their dispute and help them to know that you are a certified mediator, you have the skill, and you assisted them. Do they like you? Say yes. If you have somebody tomorrow, refer them to me. That is how you do. Let the people get to know you. And before you know it, they will make reference. But first, you must put your head down. Don't be looking for money. Look for how you can develop your skills and how people will get to know you in that field. And once you do that, You don't need any other thing. As a lawyer, you know what to do. You file a process. Even as a non-lawyer, you get your lawyer senior colleagues that have been called to bar. You say, oh guys, this is the terms of settlement. I want it to become the judgment of the court. They know how they will do it for you. So that is just that about it. And then yes, the issue of being private has been addressed. I think basically those are the things about your questions. So thank you very much for being on the group. We can talk further. Thank you very much for those questions. I hope we've contributed. So I think we have one person. One last person before we call it a day. I think we have done. Is there any other?
I think the person is no longer on the call. The person who wanted to ask is no longer on the call.
Okay. So you say you have some question in the chat box. Maybe let's address it in 1 or 2 minutes and then we're out of here. Yeah. So
hello,
okay.
Can we all hear me?
So we have some questions here. Number one, to what extent is a decision from an ADR process binding on the parties? And to what extent is it enforceable by the court of law? If it is the parties that agreed on the decision, it is binding on them. More importantly, when it is before a court or before an ADR judge, if it comes from the parties and the parties said, yes, that is their decision, and he stamps on it, it becomes an agreement that is enforceable. So enforceability, if you can take your agreement to a multi-door courthouse, you can take your agreement and file a matter in court for interpretation of the content and say, based on this agreement you have, the court should decide whether this is binding and enforceable. And if it is, the court should give effect to it. You see, you can do that. Another option is to go to a court that has jurisdiction, file a civil suit, claiming what you want to claim, then you come with the terms of settlement and it will be adopted. So it's actually binding and enforceable. In fact, it is preferable because consent judgments cannot be set aside and it cannot be appealed except if you establish the ground of fraud. I hope that's okay. Okay, thank you for putting the questions together. I have a question for our mentees, and it is that in what situation exactly will it be suitable to advise parties to opt for ADR? All situations except that of criminal or when matters are against public policy. But if it is minor matters that can be treated using restorative justice, parties can actually sort them out. Yes. So secondly, does international arbitration differ from traditional arbitration? What you have is international arbitration and domestic arbitration. When the parties are locally, let's say a company in Nigeria and another company in Nigeria have a dispute, you call that one domestic arbitration. Or an individual in Nigeria is having a dispute with another individual here in Nigeria, this domestic dispute. But where there is a dispute where one of the parties in Nigeria and another party is in another country, that becomes an international arbitration. I don't know, the person who asked this question, I hope you understand. So basically, they are all arbitration, but if it is international, maybe depending on the institution in which you are doing the arbitration in, it depends on the institution. Then number 3, in what types of dispute, family, commercial, workplace, is mediation most effective? Mediation is effective in all of them, depending on the effectiveness also of the mediator, because the mediator can actually crash the mediation session if he does not have the patience and the expertise that is needed. That's professionalism. When you come and start insulting the party, say, I'm doing all my best to help you resolve your dispute, and you are here. Do you want? I beg, just leave this place. When you do that, you bring the mediation to an end. But aside from that, whether in family or commercial or workplace or landlord and tenant, mediation is actually very effective. How do negotiation and mediation compare to litigation in terms of cost, time, and flexibility? Litigation, is a formal setting. You file a case, they assign it to a judge, the chief judge or the chief magistrate will assign it to the court that will handle it. You cannot choose the judge that will handle your matter. Your own is to go. And when you go there, you make your presentation, you file your papers, they ask you questions, they cross-examine you. Everything you do is within the public domain, and anybody can go and apply for a certified true copy of it. Unlike mediation or arbitration, that is private. It's not everybody that can come into the room where you're doing negotiation or arbitration or mediation. Not everybody can come in there. It's private, it's confidential. Now, issue of cost, if it is institutional, those institutions have costs that are clearly stated. So, but if it is ad hoc, it means that it is not institutional, it's private and personal, so you can negotiate your fees. So when you look at it, the efficiency, will you rather use 6 months to resolve a matter or use 2 years or 3 years to resolve it in court? So you look at it, yes, ADR is effective, and then when you are looking at cost varies. If they say pay 1 million naira to get your matter resolved within 6 months, or pay 500 or 300,000 naira and get your matter resolved in 2 years, which one will you go for? So which one is actually cost effective if you are looking at it? Imagine you collect a loan and your money get hooked, and every month the interest is growing. Which process do you think is going to address your issue immediately? Sorry, let me confirm if you are hearing me or anybody is listening to me.
We can hear you, sir.
Yes, sir.
I hear you, sir.
Yes, so when you talk about cost, the time, but when it comes to time is relative. So to say, you cannot say time, but in most ADR cases, they are resolved, their time span or limits are shorter compared to litigation, where you have to go for mention. In fact, they say, they have not served one of the party, you have to apply for motion for substituted service. You go and serve by substituted means you come back again. They adjourn it for further mention, then they adjourn for hearing, and the hearing, one party did not come, you say you need to go and serve it. Then when hearing, one person do and cross-examine. After 1 or 2, they say we are tired, though there are other cases, adjourn it. Then the other witness will come. Before you know it, the year is gone. You are just on one side. So when you are looking at cost, you are looking at timing. You look at it. But in ADR, you can fix the time. We want to appoint a mediator or arbitrator. We want to sit from day to day, from the day of commencement till we finish. That is at the party's discretion. So they can decide that. So you can see that in ADR, it is party driven. They decide the time, they decide the cost, they decide the venue, they decide the place where the meeting is going to be holding, they decide everything. In litigation, you cannot do that. You don't have control over it. It's only the outcome that you have to do it together in ADR. but in litigation you cannot say. Should ADR be mandatory before litigation in some cases? Yes and no. The issue is that whether you say it's mandatory or not, it's subject to the parties. If you say you are forced to go and settle your matter and you go there and you refuse to talk, you see we are still going back to the same this debate. You know, there are matters that you should attempt to settle. So when they say it's mandatory, meaning that you must go and attempt settlement before you come to court, that will be good. And we're advocating that that should be done, because if you go to some of our courts, you see that cases are lined up. Matters are lined up. Plenty cases. So, and then you'll be wondering, say, how this matter, if they have gone for mediation, they would have settled it since. So you see, we'll advise that you go for mediation. So if they can make it mandatory, that would be good. But for the fact that it is mandatory does not mean that parties must participate. They still use their will. So at the end of it, you cannot take away the right of the parties. In what way is ADR different from court litigation? We have explained that. Why might negotiation be unsuitable for some disputes? Negotiation takes place only between the parties in the dispute. It does not actually involve a third party. So that's what you need to understand. It's when the parties are not able to resolve, then they bring a third party neutral who is an expert in that field to help them resolve their disputes amicably. What role does power dynamics play in negotiation, and how can weaker parties effectively negotiate with stronger parties? It is the mediator or the negotiator, if they are on both sides. I think this question has been attempted. It is the mediator or the arbitrator that will have to use his skills. So, where you see that one party has more power than the other, you are the one to protect the other party. You need to find out, is it that it's not comfortable to speak in the presence of the other party? If that's the case, there are options you can use. You can say, let us break into, you can do what is called short-term mediation. You go and meet this person. When you talk, you now go and meet the other person, you talk, that's how you keep shuffling from one room to the other until you get to a point where your matter is resolved, or you bring the parties to a point where they can come together. So that is your role. It depends on your expertise to know what do you do at that point in time. So power dynamics is actually real. So as a negotiator, as a mediator, you are the one to develop strategies on how to diffuse that power and give the parties the ability to negotiate on equal footings. Okay, I think those are the questions that we have, and I think we have answered them. All right. Dennis, over to you. I think we have answered the questions.
All right. Thank you very much, sir. Thank you for helping us.
Who wants to give any parting words or contribution? Okay, Omotayo.
Yes, sir, I just want to add that in as much as we can use ADR or mediation in family matters, but I would like to mention that it does not work for divorce. So divorce has to go through, even though it's part of family matter, but it has to go through litigation, sir.
I personally do not I don't handle divorce matters, but when you talk of family matters, there are a lot of other family issues like inheritance, like disputes, quarrel between father and mother, not talking to each other, a lot of things in family. Divorce is one of it. Divorce, depending on what the type of marriage that is being conducted. If it is a marriage under the act, only the court can divorce the parties. But any other things surrounding maybe joint properties, custody of children, our finances, our house, all of those things you can settle it. If I'm coming into mediation, it is a family where they are going for divorce, I try as much as possible to help the parties resolve. When they decide that they want to go their separate way, I will remove myself from the situation. The same thing happens when it comes to litigation. If I'm handling a divorce matter, it's for the purpose of parties to settle. If they say they are not settling, I will allow them. I don't want to take part in their separation because I don't want to separate with my wife and I don't want to lay the foundation. So I don't do it. Other people feel no, I'm not the one separating them, they are the ones separating them. So let me just help them separate, so that they will live in peace. So that is their own. But for me, I don't do it. So you don't use mediation to divorce and say parties have agreed to divorce. No. If it is a marriage under the act, the court must pronounce. The court must be the one to dissolve the marriage dissolution. It is the court. But any other thing surrounding the marriage can be resolved via mediation. And if you resolve every other thing, all you need to go before the court is I say parties have agreed to go their personal ways and they have agreed on terms. And this is what they say they agreed. And the court will now adopt it and becomes a consent judgment of the parties. Thank you very much, Omotayo, for that contribution. And I hope that the mentees are taking note. You don't use mediation to divorce people. You only use mediation to resolve every other conflict around the issue of divorce. And if they want to divorce, you take it to the court that has jurisdiction, and then having settled all other issues around it. That will not take you people time in court, and that will be sorted out. Is that okay? If you are in the house, a mentee, you are in the house, please can you give me a thumbs up? There is only one person, 2, 3, 4, 5. Okay, only 5 people. Oh, okay. Oh, that's good. Thank you. Thank you for staying back. Please, parting words from mentors, just in 2, 3 seconds. We have done justice to the overview. We look forward to the next week task, which is mediation and career opportunities in mediation. Please begin to work on it. All right. So, mentors, do we have any parting words? 1 minute, maybe 2 seconds, 3 seconds, your parting words for today till meet next week. All right. Dennis, over to you.
Yes. All right. Thank you very much, Mr. Nyacham, for to our mentors that were able to stay to the end of the class for such a very detailed and very insightful session. Quite a lot has been covered within this first class. We apologize for the slight overshoots in class. A lot of things had to be addressed. So thank you once again for the questions. We really appreciate the mentees that asked. And to the mentors also, we thank you also for answering those questions. Please do not forget to share what you have learned on your social media platforms. Tag our mentors. Their flyers have been shared to you, so you can accurately know their name. Search for them on LinkedIn. LinkedIn when you are making your posts. All right. Please do not forget to fill in the attendance to show that you have been a part of this class. All right. We'll be taking into consideration your attendance and every other thing. All right. So thank you once again for being a part of this session. We look forward to having you all in the next session. When the roles and the tasks are assigned, please do well to follow through with all the activities It is part of the learning process to ensure that you get the full benefits out of this particular course. Thank you, everyone, for being in today's class. Please do enjoy the rest of your evening.
Please, when you are making posts, ensure that you tag JIIPCC, tag Shati, Settlement House ADR Training Institute on LinkedIn, then tag the mentors. Please do that for us, and let's make noise about what we have learned. God bless you. See you next week.
Thank you very much, sir. Good night.